Hey guys, tonight we're stepping into one of history's most consistently absurd institutions, the long, elaborate, and frankly unhinged tradition of telling women what they absolutely cannot do. Not the big political stuff, though we'll get there, but the truly specific, baffling, and sometimes deeply personal prohibitions that have followed women across centuries, continents, and absolutely no logical reasoning whatsoever. We're talking about rules so specific they had to have been written by someone who was personally threatened by a woman doing something completely harmless. A massive thank you to the viewer who suggested this topic. You know who you are, and honestly, this one's for you. Your ideas are the engine behind this channel, and I mean that. If you haven't already, please like and subscribe, but only if you genuinely enjoy what I do here. It really does help, more than you know. Drop a comment and tell me where in the world you're listening from and what time it is for you. Someone out there is always doing this at 2 a.m, and I respect that deeply. The channel is also now live on Spotify, so if you prefer to listen there, the link's waiting for you in the description. Now, dim the lights, put on a fan, get comfortable, adjust that pillow, tuck in your feet, because the rules we're about to discuss are genuinely so strange that your toes deserve protection. Let's pause for a moment before we begin, because there are real questions here. Did women in ancient Rome actually get in trouble for drinking wine? Could a woman in medieval England be legally punished for talking too much? Was there a point in history when women weren't allowed to wear the colour red, ride a horse in a certain direction, or simply walk outside without a male relative trailing behind them like an anxious shadow? Were their professions so thoroughly locked down that a woman's presence was considered not just inappropriate, but genuinely dangerous to the outcome? Did anyone actually sit in a room somewhere and write down, officially, that women were forbidden from whistling? And if so, who was more afraid in that room? The people writing the rule, or the woman they were writing it about? Congratulations. You've just woken up sometime in the last 4,000 years of human civilization, and somewhere nearby there's a man with a scroll, a law, a deeply held opinion, or all three, absolutely convinced that you, specifically you, and what you are doing right now need to stop. Good luck. In ancient Rome, long before emperors started poisoning each other at dinner parties, there was a rule so committed to controlling women that it made drinking wine not just improper but technically illegal, and husbands were legally permitted to kill their wives for violating it. The reasoning, delivered with full senatorial gravity, was that wine led to adultery, and adultery led to chaos, and chaos was, apparently, a beverage only men were equipped to handle. Women caught drinking could be divorced on the spot, shamed in public, or subjected to the kind of moral lecturing that would make even the most patient person reach for a drink. The ban held for centuries, mostly in the Republic era, enforced with the kind of righteous determination that tends to collapse the moment the people enforcing it want something from you. In this case, women who were expected to pour the wine, serve the wine, and quietly pretend wine did not exist while everyone else at the table drank themselves sideways. It is, historically speaking, a lot. The specific law invoked most often was the Lex Oppia, passed in 215 BCE during a period of wartime austerity, and later expanded by custom and cultural expectation far beyond what any single law could contain. The formal version targeted luxury broadly. No woman was to possess more than half an ounce of gold, wear multicolored garments, or ride in a carriage within a mile of Rome during public ceremonies. But the wine ban operated on a different level. It was social, moral, and domestic, enforced not by magistrates but by husbands, fathers, and the watchful collective opinion of neighbors who were always, in Rome, paying close attention to what everyone else was doing. The punishment for a woman found drinking could be death, not officially sanctioned execution, but the kind of informal justice a husband was permitted to enact within his household. Roman legal scholars record cases of women beaten, divorced, and in extreme examples, killed for drinking wine, with the men involved facing no legal consequences because the household was, legally, his domain, and she had violated its terms. This is the part of Roman civilization that the marble busts and epic poetry tend to leave out. What made this particularly absurd was the geography of Roman social life. Wine was everywhere. It was served at every gathering, poured at every religious ceremony, offered to guests as a matter of basic hospitality. The Roman diet included wine so routinely that historians estimate the average adult Roman consumed more than a litre of wine a day, which explains a great deal about Roman governance. Women moved through this world daily, hosting dinners, attending festivals, managing households that revolved around the production and storage of wine, while being prohibited from touching so much as a cup. The ban began to erode, as most impossible rules do, under the pressure of practical reality. By the imperial period, women of the upper classes were drinking openly at dinner parties without anyone getting killed for it, which suggests the rule had shifted from legal standard to social preference. The least enforceable category of rule there is. Wives of emperors hosted lavish banquets. Wine was a central feature. Nobody sent for a magistrate. But the logic behind the ban, that women's behavior in private was men's public responsibility, that female pleasure was inherently suspicious, that a woman relaxed enough to enjoy herself was a woman insufficiently supervised, that logic did not go anywhere, it just changed clothes, which is also the whole story of the next 2,000 years. Pour yourself a glass, you've earned it. The ancient Greek gymnasium was, theoretically, a place of education, philosophy, athletic training, and the cultivation of the ideal citizen, which meant, by definition, it had absolutely no room for women. You could be a goddess of wisdom, a poet of legendary skill, or simply a woman who wanted to run without being chased by something. None of it mattered. The gymnasium was male space, full stop, and the idea of a woman entering one was treated less like a practical concern and more like a philosophical affront. In Sparta, things were slightly more complicated because Spartan women were expected to stay physically strong enough to produce strong soldiers, which meant some exercise was acceptable, but only the right kind, in the right place, under the right conditions, ideally not where anyone important could see them doing it with any enthusiasm. The gymnasium in ancient Greece was not simply a place where people exercised. It was an institution. It was where boys became citizens, where philosophers gathered students, where physical excellence and intellectual life were understood to be the same pursuit, Socrates taught in the gymnasium. Aristotle walked its colonnades. To be educated in Greece was, largely, to be educated there, which meant that excluding women from the gymnasium was not merely excluding them from running laps, it was excluding them from the entire project of civic and intellectual life. Women's education in the classical Greek world varied somewhat by city-state, but the general principle was consistent. Women's domain was the household, and the gymnasium was emphatically not the household. In Athens, respectable women lived in the gynoeceum, the women's quarters of the house, and appeared in public primarily for religious festivals and funerals, the two occasions where female presence was ritually required and therefore permitted. The idea of an Athenian woman slipping on a chiton, heading down to the gymnasium, and joining a philosophical discussion would have read, to most Athenian men, as a scene from a comedy. The comic playwright Aristophanes wrote exactly these kinds of scenes, and they got laughs, because the image of women exercising civic power was, to the Athenian male mind, inherently ridiculous. Sparta is the exception that makes everyone uncomfortable because it complicates the narrative without quite overturning it. Spartan women did exercise. They ran, wrestled, threw the javelin, and trained physically in ways that would have scandalized Athens. But the purpose of this training was specific and unapologetic. Spartan women were being cultivated as mothers of warriors, and a healthy mother produced a healthy soldier. The exercise was not an acknowledgement of women's autonomy. It was a public health policy. The Spartans were not feminist. They were efficient, which is a different thing entirely. There was, however, one athletic competition at Olympia specifically for women, the Heraia, a foot race held in honor of Hera, run in the same stadium as the men's games, but at a separate time. Because heaven forbid a woman's athletic achievement and a man's athletic achievement occupy the same afternoon. The Heraia was ancient, respected, and almost entirely ignored by the historical sources that describe the Olympics in exhausting detail, which tells you something about which events ancient writers considered worth recording. The gymnasium's exclusivity was not incidental, it was the point. A space where male intellectual and physical excellence was cultivated had to be male, because excellence, in the Greek civic imagination, was gendered from the ground up. The women of Athens who were educated, like Aspasia, the partner of Pericles, who by all accounts was one of the sharpest minds in the city, were educated privately, informally, and often held up as curiosities. Impressive, yes. Exceptional, certainly. Evidence that the system needed changing? Not yet. That argument was going to take a while. In medieval and early modern England, if a woman was deemed to have spoken too sharply, too often, or simply too much for the comfort of the men around her, there was an official corrective device ready and waiting, the scold's bridle, also known as the branx. It was an iron cage fitted over the head with a metal bit pressed into the mouth to prevent speech, and it was used with the full endorsement of local authorities on women accused of being quarrelsome, gossiping, or just generally expressing opinions that nobody had requested. The woman would then be led through the town on a chain, so that the community could observe the correction taking place, which tells you a great deal about what medieval towns considered entertainment. The offence had a name, scolding, and it was aimed almost exclusively at women. Men who argued loudly in public were passionate. Women who did the same were a public nuisance requiring ironwork. The scold's bridle appeared in England and Scotland from roughly the 16th century onward, though records suggest earlier versions existed in various forms. The device itself was designed not just to prevent speech but to humiliate. The iron cage sat visibly on the head, the bit pressed down the tongue, and the wearer was paraded through the town centre as a public lesson in the consequences of female volubility. Townspeople were invited to watch. Some accounts describe spectators laughing. It was punishment as performance, correction as communal entertainment, and it was entirely legal. The crime of scolding, the legal term was most commonly common scold, or in Latin, communis rixatrix, was a recognised offence under English common law. A woman convicted of it could be subjected to the bridle, the cucking stool, or both. The cucking stool, later more commonly called the ducking stool, involves strapping the convicted woman into a chair mounted on a long lever arm over a body of water and repeatedly plunging her into it, which was considered a proportionate response to the crime of being verbally difficult. Neither of these punishments was applied to men. A man who argued publicly was exercising a right. A woman who did the same was committing a misdemeanor. What counted as scolding was, conveniently, flexible. A woman who argued with a neighbour could be accused. A woman who disputed her husband's decisions loudly enough for others to hear could be accused. A woman who gossiped, and in small medieval towns, everyone gossiped, it was the primary information network, could be accused. The threshold was not objective. It was whatever the local magistrate, who was always a man, decided fell outside the range of acceptable female behaviour on a given day. The subjectivity was not a flaw in the system. It was a feature. The last recorded use of the ducking stool in England appears to be in 1789, which is well into the era of the Enlightenment, the Industrial Revolution, and the publication of works arguing forcefully for universal human rights. The branx continued in private use, according to some records, even later. Progress is slower than it tends to appear in retrospect. What the scold's bridle actually was, stripped of its legal language, was a device for encoding a simple message in iron. Women's speech was the problem, not the conditions that gave women something to complain about. The houses that flooded, the husbands that drank, the wages that were withheld, the taxes that were extracted, none of that required correction. The voice that described those things did. The bridle is gone. The instinct that produced it took considerably longer to address, and some would argue the argument is still ongoing, just conducted without the metalwork. The ancient Olympics were a celebration of human athletic achievement, divine honour, and the absolute certainty that women should not be anywhere near any of it. Married women, specifically, were barred from attending the games entirely, not from competing, which was already unthinkable, but from watching. The punishment for a married woman found at Olympia during the games was, depending on the source, to be thrown from a cliff, which is a remarkably permanent solution to what was essentially a seating dispute. Unmarried girls were permitted to attend, in a compromise that managed to be both slightly more generous and significantly more confusing. The reasoning appears to have been partly religious, partly territorial, and partly the specific brand of ancient logic that treated women's presence as inherently disruptive to male performance, a concern that has, historically speaking, aged poorly. The site of the Olympic Games was sacred ground dedicated to Zeus, and the athletic contests were religious rites as much as sporting events. Athletes competed naked. The word gymnasium itself derives from the Greek gymnos, meaning naked, and the nakedness was understood as both practical and sacred, a presentation of the human body in its most honest form before the gods. The exclusion of women was, in part, framed as a religious protection for this sacred masculine space. Women were not supposed to see it. More precisely, women were not supposed to see it and remain in the audience having seen it, because what might follow from that was, apparently, not worth examining closely. The cliff in question was Mount Typeon, and Pausanias, the Greek travel writer of the 2nd century CE, mentions it in his account of Elis as the prescribed punishment, while noting that in his own time no woman had actually been thrown from it, which he records without irony as a kind of reassuring footnote. The punishment existed. It was just apparently a sufficient deterrent. The logic was circular in the way that the most durable social rules tend to be. Women were not allowed because they were not allowed, and the severity of the punishment for violating the rule confirmed that the rule was serious, which made the rule feel legitimate, which made the punishment feel proportionate. Unmarried girls were permitted to attend the games, and this exception has puzzled historians pleasantly for quite some time. The most persuasive explanation connects it to the Olympic Games as a site for viewing eligible young men. The Games served a social function beyond athletics. And the visibility of young male bodies to unmarried young women was understood as serving dynastic and social purposes. Marriage, unlike adultery, was useful to the state. So unmarried girls could look, married women could not. The logic hinges on a distinction between observation that serves social reproduction and observation that threatens it, which tells you what the restriction was actually about, and it was not about religious purity. Kallipateira is the story most often cited in this context. She was the daughter, sister, and mother of Olympic champions, and according to the story, she disguised herself as a trainer to watch her son Pisirodus compete. When he won and she leapt over the barrier to reach him, her disguise slipped and she was discovered. The officials, faced with the daughter, sister, and mother of champions, decided not to throw her off the cliff. She was released. But from that point forward, the story goes, trainers were required to attend the games naked, just like the athletes, so that no one could hide in their clothing. One woman's joy at her son's victory resulted in a dress code for an entire profession. That's a legacy. For centuries across England and America, when a woman married, she legally ceased to exist as an independent person. This was not a metaphor. Under the doctrine of coverture, a married woman's legal identity was absorbed entirely into her husband's. She could not own property, sign contracts, keep her own wages, sue anyone in court, or be sued, because in the eyes of the law she was not a separate entity. She was covered, hence the name, by her husband, like a legal blanket had been thrown over her entire personhood and tucked in at the edges. A woman could spend years building a business, and the moment she married, it belonged to him. She could inherit money from a relative, and it immediately became his. She could be beaten by him, and the law had surprisingly little to say about it, because you cannot, technically, assault yourself. Coverture wasn't abolished in England until the late 19th century, and versions of it persisted in American law well into the 20th. The doctrine had a name because it needed one, femme covert, from the Anglo-Norman French, meaning a woman covered. Her legal counterpart, the unmarried or widowed woman who held her own legal identity, was the femme sole, a woman alone in the legal sense, meaning a woman who existed. The language built the assumption directly into the vocabulary. A married woman's natural state was covered. Alone, meaning legally present, was the exception that required its own terminology. Sir William Blackstone, whose commentaries on the laws of England published in the 1760s became the foundational legal text for both British and American lawyers, explained coverture with the serene confidence of someone describing the weather. By marriage, the husband and wife are one person in law, and that person is the husband. This sentence was read by generations of law students, applied in generations of courtrooms, and cited in generations of judicial decisions with the kind of authority that comes not from its logic, but from how many times it had already been repeated. The practical consequences of coverture were total. A woman who had run a shop before marriage could not legally continue to run it under her own name after. Her wages from any work she performed belonged to her husband. If she was injured and wished to sue for damages, her husband had to bring the suit. He had to sue on her behalf for harm done to her body, because the body in question was, legally, partly his. If she wished to leave a marriage and take her children, she could not, because the children were his property. If she inherited money from her own family, it became his immediately upon receipt. The Married Women's Property Act in England in 1870 allowed women to keep their own earnings and inherit property, a change that was described at the time by opponents as an attack on the family, on marriage, and on the natural order, which is the standard response to every legal advancement for women across the entire historical record. The full legal equality of married women in English law arrived in increments across the following century, with each increment generating its own round of warnings about civilizational collapse that somehow never materialized. In America, the pace was similarly measured. The Seneca Falls Convention in 1848 listed coverture explicitly among its grievances. The legal reforms came state by state, decade by decade. The last remnants of coverture doctrines, particularly around marital rape, which was not legally recognized as possible in many American states until the 1970s and 80s, because a wife was understood to have given permanent consent through marriage, were among the most resistant to change, because they were attached to the most intimate spaces of women's lives, where the law, historically, had been most comfortable looking the other way. Paris, as recently as 2013, had a law on the books, a law written in 1800, that technically required women to seek police permission before wearing trousers in public. The law was never formally enforced in its later decades, and had been partially relaxed in 1892 to allow for women on horseback, and in 1809 for women on bicycles, because apparently the bicycle created a trouser emergency that had to be legislated immediately. The original intent was to keep women out of male spaces by keeping them out of male clothing, which was, for a long time, considered the same thing. Women who wore trousers were read as threatening the natural order, not because of the fabric, but because of what the fabric implied: mobility, practicality, and the deeply unsettling possibility that women were going places without asking permission first. Trousers on a woman carried a specific charge across several centuries of European and American history, and the charge was not about modesty in the usual sense. It was about legibility. A society organized around visible gender difference needed women to be visually identifiable as women at all times, and the fastest way to ensure that was to make their clothing non-interchangeable with men's. Trousers blurred the line. Trousers suggested that the line was blurrable. In a culture that had organized property rights, professional access, legal status, and political participation around gender, anything that made gender harder to read at a glance was a minor administrative crisis. The women who pushed back against this were systematic about it. The dress reform movement of the 19th century, associated in America with figures like Amelia Bloomer, argued plainly that women's clothing was a health hazard, that corsets, petticoats, and heavy skirts restricted movement, caused physical injury, and served no purpose except to enforce an aesthetic that happened to limit women's physical freedom. The garment proposed as an alternative was a looser tunic over wide trousers gathered at the ankle, which is about as radical a design as a sensible pair of work pants. It was called the Bloomer, after Amelia Bloomer, who publicized it, and the reaction to it was so intense that the women advocating for it eventually concluded the controversy around their clothing was distracting from the causes they actually cared about: voting, property rights, education, and reluctantly went back to skirts. George Sand wore trousers in Paris in the 1830s, and was among the first women to obtain one of the police permissions the law required, which she described as extremely useful, since it allowed her to walk around the city without being instantly identifiable as a wealthy woman and therefore without attracting attention. She used trousers as a tool of practical freedom. Observers used her trouser wearing as evidence of her general moral irregularity, which also tells you something about the period. The military provided one of the more interesting pressure points on trouser prohibition. Women who served in various capacities during both world wars were issued uniforms that included trousers, because trousers were practical and the war required practicality, and practicality had a tendency to override etiquette when something important was at stake. After each war, there were serious cultural conversations about whether women should revert to dresses, which seems in retrospect like the wrong conversation to be having, but was conducted with great seriousness by people who had just watched women run supply chains and build aircraft. Katharine Hepburn wore trousers throughout her career and was famously ordered by a studio executive to stop. She ignored him, and her trousers were confiscated by a studio assistant, and she walked around the studio lot in her underwear until they were returned. This is the kind of action that, depending on your perspective, reads as either eccentricity or clarity, but either way it worked. The trousers came back. She wore them until she died. Our row. For most of recorded Western history, the idea of a woman practicing medicine was considered either laughable or dangerous, depending on who you asked. Women had, for centuries, served as midwives and healers with extensive practical knowledge, and then, as medicine formalized into universities and professional licensing, that knowledge was systematically excluded from the new institutions. Medical schools across Europe and America refused to admit women, and the arguments deployed against them ranged from the physiological women's brains were unsuited to scientific thinking, to the moral, exposing women to the realities of the human body would corrupt their femininity, to the simply circular medicine was a male profession, because men were the ones allowed to study it. Elizabeth Blackwell became the first woman to receive a medical degree in the United States in 1849, after being rejected by so many schools that her eventual acceptance by Geneva Medical College was apparently treated as a practical joke that got out of hand. The exclusion of women from formal medicine was not the beginning of the story. It was actually a reversal. In medieval Europe, women had practiced medicine regularly, as healers, herbalists, midwives, and in some documented cases as licensed physicians in Italian university towns, where the rules were briefly more flexible than they would later become. Trotula of Salerno, a figure who may have been one person or several conflated together, produced texts on women's medicine in the 11th and 12th centuries that were used as teaching references across Europe for hundreds of years. The medical knowledge existed. The practitioners existed. Then medicine got organized, and organized medicine decided it was a male profession. The process was largely one of credentialing. As universities formed and medical licensing became the standard for professional practice, the universities and licensing bodies were controlled by men, and the decisions about who could enter and who could be certified were made accordingly. The practical knowledge of women healers did not disappear. It continued in domestic medicine, midwifery, and informal care, but it was redefined as not medicine, as folk practice, as the less important category that real doctors supervised from above. By the 19th century, the arguments against women in medicine had calcified into specific forms. Women were too delicate for the physical realities of medical practice. Women would be corrupted by studying anatomy. The presence of women in medical schools would be disruptive to male students, whose education was therefore more important to protect than women's access to a profession. Women patients, it was argued, actually preferred male doctors, an assertion made by male doctors about their female patients, which is a methodology with a few flaws. Elizabeth Blackwell's path is worth sitting with. She was rejected by every major medical school she applied to. Geneva Medical College in New York admitted her in 1847, after the student body voted on her application as what they apparently believed was a joke. They voted yes as a prank, and then had to honor the vote when she showed up. She graduated first in her class. She then went to Paris for clinical training and was denied access to the hospital wards being permitted only to study in the midwifery division. She later founded the New York Infirmary for Indigent Women and Children and a women's medical college. The system did not make room for her. She built a parallel system, which is the move available to people when the existing one refuses to open its doors. St. Paul wrote it, the Church enforced it, and for centuries women in Christian congregations were expected to receive spiritual guidance in complete silence. The instruction appears in the first letter to the Corinthians. Women should keep silent in churches, and if they want to learn anything, they should ask their husbands at home. This was interpreted with varying degrees of rigidity across different traditions and centuries, but its legacy was durable and wide-reaching. Women were barred from preaching, from reading scripture aloud, from voting in church governance, and in many cases from any form of audible participation in the services they were required to attend. The Quakers, beginning in the 17th century, were among the first Christian groups to formally permit women to speak in meetings, and were treated by many of their contemporaries as if they had suggested something genuinely radical, which, given the context, they had. The scriptural basis was debated even among early Christian scholars, partly because Paul's letters contain apparent contradictions. In Corinthians, he instructs women to be silent, but elsewhere he describes women who prayed and prophesied publicly, which presumes some form of speech. The theological consensus resolved this tension in the way theological consensus tends to resolve tensions that are inconvenient, by deciding that the restriction was the rule and the exceptions were the exceptions, and proceeding accordingly for the next 1500 years. What this meant in practice varied considerably by denomination and century. In the Catholic Church, women were barred from the priesthood entirely, could not administer sacraments, could not preach from the pulpit, could not celebrate Mass. In many Protestant denominations, the same rules applied informally, even where they were not formally codified. Women could sing in the choir, women could teach children, women could organize church fundraisers, maintain the building, prepare the altar, and manage the social infrastructure of the congregation, all the labor, in other words, with none of the authority. This arrangement was described, frequently, as complementary rather than unequal, a framing that has not aged particularly well. The Quakers, the Methodists, and eventually various evangelical movements broke with this tradition for different reasons at different times, and each break was treated as a test of religious seriousness by the institutions that hadn't made it yet. The argument against women preaching in the 19th century relied heavily on Paul's instruction, on the authority of tradition, and on a specifically interesting claim, that the emotional nature of women made them persuasive in ways that bypassed rational judgment, meaning women preachers were dangerous not because they would say wrong things, but because people might listen to them. The fear was not incompetence. The fear was effectiveness. Sojourner Truth, who could not read, preached anyway in the 19th century with sufficient power that her sermons were recorded by others and are still cited today. Jarena Lee requested formal ordination from the African Methodist Episcopal Church in 1819 and was refused. She preached anyway, for decades, to enormous congregations. The church later acknowledged her ministry in the way institutions acknowledge things that happened without their permission, slowly, retrospectively, and with somewhat less enthusiasm than the people who had been doing the thing deserved. The Church of England voted to ordain women as priests in 1992, which is recent enough that many of the people who were opposed to it are still alive and can tell you about it. The Catholic Church's position has not changed. Paul's instruction, written in the 1st century CE to a specific congregation in Corinth about a specific disruption in their specific meetings, has done more sustained institutional work than perhaps any other sentence in the history of organized religion. For most of legal history, women existed in the courtroom in exactly one capacity, as witnesses or defendants. They could not serve as lawyers, judges, or jurors because the law was considered a rational profession, and women were considered, officially, in legal texts, with citations, to be creatures of emotion rather than reason, and therefore constitutionally unsuited to the dispassionate weighing of evidence. In England, women were not permitted to serve on juries until 1919. In the United States, some states excluded women from jury service well into the 1960s. The practical effect of this was that crimes committed against women were judged entirely by men, using laws written by men, enforced by men, in a system that had been designed from the beginning without consulting the people it most frequently failed. Myra Bradwell applied to the Illinois bar in 1869 and was denied. The Supreme Court upheld the denial. One justice wrote a separate opinion explaining that the natural timidity of women made them unfit for the conflicts of the bar. He wrote this in a legal opinion. It has been preserved. The courtroom exclusion was not incidental to the legal system. It was foundational. Law, as a discipline, justified its own authority through claims of reason, objectivity, and universality, and then built those claims on a system that excluded half the population from participation. The circularity was self-sealing. Women were absent from the creation of legal principles, so legal principles did not account for women's perspectives. So the legal system functioned in ways that disadvantaged women, so women's attempts to participate in reforming the system were judged by the same system that needed reforming. This is not a flaw in the logic. It is the logic. The jury exclusion had consequences that were specific and traceable. Rape cases were tried before all male juries, applying a legal standard that required proof of physical resistance, a standard that reflected not the reality of sexual violence, but the assumptions of men who had never been sexually assaulted and were reasoning from a position of considerable remove. Domestic violence cases were handled by courts that considered marital disputes private matters and were reluctant to intervene in a man's household. The legal category of marital rape did not exist in many jurisdictions until the 1980s, literally could not exist, because the legal system had been built on coverture's premise that a wife's consent was given permanently at marriage. Belva Lockwood is another name worth knowing. She was refused admission to the bar of the United States Supreme Court in 1876 on the grounds that the court's rules referred to male attorneys and she did not meet that description. She petitioned Congress to change the rule. Congress changed the rule in 1879. She was admitted to the Supreme Court bar that same year, became the first woman to argue a case before the court, and later ran for President of the United States in 1884 and 1888 on the Equal Rights Party ticket. Because if the system won't let you in through the front door, you can always run for the position that appoints the people who guard it. Sandra Day O'Connor graduated third in her class from Stanford Law School in 1952 and could not get a job at a law firm, only offers to work as a legal secretary. She became the first female Supreme Court justice in 1981, the same profession, 29 years. That gap is not an abstraction. It is the careers of specific women, the cases that were never brought by lawyers who were never hired, the outcomes that went differently because the reasoning was incomplete. In the United States, a married woman could not open a bank account in her own name without her husband's permission until the Equal Credit Opportunity Act passed in 1974, not 1914. Not 1944. 1974. The same decade that gave the world disco and the microwave oven. Before that, banks could, and routinely did, refuse to issue credit cards, loans, or accounts to women unless a male cosigner vouched for them, because a woman's financial judgment was not considered independently reliable. This was not a theoretical barrier. Women who had worked for decades, built savings, and managed households were legally treated as financial children requiring adult supervision. Gloria Steinem famously noted that she could not get a credit card in her own name despite being a well-known employed journalist, and had to have a man co-sign for her. The financial exclusion of women was not a single law but a system, a web of practices, policies and assumptions so thoroughly interlocked that removing any one piece of it left the rest largely intact. Banks that technically could not refuse accounts to women on paper could decline them for insufficient credit history. Credit history they lacked because they hadn't been allowed to build it. And women whose credit was folded into their husbands had no independent financial record when widowed or divorced. Women who had managed household finances for decades had nothing in their own names to show for it because the names on the accounts, the deeds, and the investments were his. The mechanics of this were domestic in the most literal sense. A woman might clip coupons, negotiate prices at the market, manage the household budget across an entire year, move money between accounts, and make every significant purchasing decision in the household, and still have no independent credit rating, because the accounts were not in her name and the assets were not hers. She was the financial manager of a household in which she had no financial standing. This is not a metaphor. It was the actual legal and institutional structure. The credit card is a useful lens because it was new enough to reveal the system clearly. Credit cards were introduced widely in the United States in the 1950s and 60s, and the credit application process required documentation of creditworthiness that women either couldn't provide because their accounts were in their husbands' names, or were denied even when they could, because lenders assessed women's creditworthiness, partly on the assumption that they might become pregnant and leave the workforce. Pregnancy, under this logic, was a financial liability that justified denying credit to an otherwise creditworthy applicant. This was legal. This was standard practice. And this was the system that required the Equal Credit Opportunity Act to dismantle in 1974. The aftermath of the act was not immediate equality. Lenders complied with the letter of the law while finding ways to operate within its spirit only grudgingly. Women of color faced compounded discrimination that the act's enforcement did not fully reach. Unmarried women, women without college education, women in lower income brackets, the act helped all of them, but it helped the women with the most existing advantages most quickly. The financial independence of women is a project that is, depending on which metrics you measure and which women you're counting, still ongoing. There's a particular quiet indignity in the financial exclusion worth noting. It made women dependent on men for basic economic survival, in a way that then made the dependency look natural. If a woman could not open an account, could not own property, could not build credit, then when a woman stayed in an unhappy or unsafe marriage for financial reasons, observers often concluded that she stayed because she wanted to, rather than because leaving would mean entering a financial system that had been deliberately arranged to exclude her. The cage was invisible because so much of it was paperwork. For several centuries in European and American culture, the corset was not merely a fashion choice, but a social mandate, and in some contexts, a moral one. Women who appeared in public without appropriate corseting were considered loose, improper, or mentally unwell. The last category used with a frequency that says a great deal about how the 19th century handled female nonconformity. The corset deformed ribs, compressed organs, restricted breathing, and caused a range of medical conditions that doctors of the era simultaneously treated and refused to connect to the garment causing them. Women who fainted were corseted more tightly to improve their posture. Women who complained of difficulty breathing were told to breathe more shallowly. The dress reform movement of the late 19th century, which suggested that women might benefit from wearing clothing that did not damage their internal organs, was received as a radical and somewhat suspicious political position. The corset's origins were practical in the loosest sense. It provided structure and shape to garments in an era before synthetic fabrics and modern tailoring could achieve those effects otherwise. But by the 16th century, it had become something more than structural. It was ideological. A corseted silhouette, narrow waist, elevated chest, rigid posture became the visual shorthand for respectable femininity, which meant that any woman who appeared without one was communicating something about her character, whether she intended to or not. The garment and the woman's virtue were understood to be connected. Loosen one, and you apparently loosened the other. The medical community's relationship with the corset is one of history's more spectacular examples of professional blind spots. Physicians throughout the 18th and 19th centuries documented, in meticulous detail, the conditions their female patients presented with: displaced livers, compressed lungs, cracked ribs, chronic fainting, digestive dysfunction, and a general physical fragility that was then used as evidence that women were naturally delicate and therefore needed protection and supervision. The connection between the garment crushing their organs and the symptoms those crushed organs produced was noted by some doctors and dismissed by most. The few who argued that corsets were the problem were accused of impropriety. Suggesting women remove their clothing in a medical context was itself considered a breach of decorum, which meant that the solution to corset-induced illness was more corseting, administered with greater care. Tight lacing, the practice of lacing a corset as tightly as possible to achieve the smallest possible waist measurement, became fashionable in the mid-19th century and was pursued by some women to an extent that compressed the waist to the point of genuine organ displacement. 18-inch waists were advertised, pursued, and occasionally achieved. The women who achieved them were admired. The women who pointed out what had been done to achieve them were considered alarmist. The fashion magazines of the period published corset advertisements alongside articles about women's fragile health with no apparent awareness of the connection. Girls were corseted from childhood in many households, not tight-laced usually, but trained early to the shape, so that the body grew accustomed to it and the silhouette was maintained without effort. This was considered good mothering. A girl whose mother did not ensure she developed a proper figure was a girl whose marriage prospects were being neglected, and marriage prospects were, for most of this period, a woman's primary economic security. The corset was not optional, it was infrastructure. The dress reform movement that pushed back against all of this from the 1860s onward understood it was arguing against something that had been built into the architecture of respectability itself. Reformers did not just want women to wear looser clothing. They wanted women to be able to breathe, to move, to exist in their bodies without constant physical restriction, and that argument kept expanding, as it tends to do, into arguments about other kinds of restriction, which is precisely why the people defending the corset were so resistant. They understood, correctly, that this was not really about clothing. The relationship between women and alcohol prohibition is one of history's stranger inversions. In ancient Rome, women were banned from drinking, while men were not. Millennia later, in the American temperance and prohibition movements of the 19th and early 20th centuries, women became the leading advocates for banning alcohol. Because alcohol was destroying the families they were legally trapped in, because a drunk husband could beat them and face no legal consequences, and because if women couldn't vote, couldn't work, couldn't divorce, and couldn't leave, then at minimum they could try to remove the thing that was making the situation worse. The Women's Christian Temperance Union became one of the largest women's organizations in American history. They were simultaneously fighting for prohibition and, quietly, for many of the same rights they'd been denied, because the moral authority they built around temperance was one of the few tools available to them. The temperance movement's relationship to women's rights is genuinely complicated in ways that resist easy summary. On one hand, the Women's Christian Temperance Union under Frances Willard adopted the slogan, "Do everything," meaning temperance was the entry point, but the agenda extended to labor reform, prison reform, suffrage, and the general improvement of conditions for women and children. Willard understood that the women who joined her organization over the issue of alcohol would, once organized, be available for other causes. She was correct. The WCTU became one of the most effective political organizing machines in American history, run entirely by women who technically couldn't vote. On the other hand, the temperance movement's moral framing required women to occupy a specific position, the pure, endangered victim of male vice, the guardian of the home and family, the innocent whose suffering justified the restriction. This was useful as rhetoric. It was also a cage of its own, a role that granted women moral authority only on the condition that they performed a particular kind of suffering femininity, that they remained victims rather than becoming agents. The moment women's temperance advocacy started looking too much like political power rather than moral plea, the opposition noticed and pushed back accordingly. Carrie Nation is the figure from this era most likely to be remembered, and not always for the reasons that serve her well. She walked into saloons in Kansas in the early 1900s and destroyed them with a hatchet, which was direct, visual, and difficult to ignore. She was arrested dozens of times. She paid her fines by selling souvenir hatchets, which suggests a level of enterprise and humor to the historical memory sometimes skips past. She justified her actions through her religious conviction that God had specifically directed her to smash saloons. And while this is not an argument that holds up in legal proceedings, it was at least honest about what she was doing and why. What both the Roman wine ban and the American temperance movement share, across 2,000 years of completely different context, is the use of women's relationship to alcohol as a proxy for something else entirely. In Rome, the ban encoded the assumption that women's desires required male oversight. In America, women's prohibition advocacy encoded the assumption that women's safety required the removal of something men were doing. In both cases, the actual subject was power: who had it, who was being harmed by its absence, and what tools were available to change the situation. The alcohol was, in both cases, almost beside the point. Until 1972, women were not permitted to officially run the Boston Marathon. The assumption, stated with scientific confidence that has since retired in shame, was that women's bodies were not designed for distance running, that running long distances would damage the uterus, masculinize the physique, and cause any number of medical catastrophes that never materialized once women were permitted to test the theory. Catherine Switzer entered the 1967 Boston Marathon by registering as KV Switzer and became the first woman to officially run the race with a numbered bib. A race official attempted to physically remove her from the course partway through. Her boyfriend body-blocked him. She finished. The medical disaster did not occur. Women were not officially permitted to run the race until 5 years later. The medical arguments against women running long distances were not fringe positions. They were mainstream, peer-reviewed, and repeated in publications that considered themselves serious. The uterus, it was argued by multiple medical authorities across the late 19th and early 20th centuries, was a delicate organ vulnerable to the jarring impact of sustained running. Excessive exercise would damage reproductive capacity. Women who ran would become unfeminine, and unfemininity was classified, without irony, as a medical outcome to be avoided. These arguments were made by doctors who had never studied women running long distances, because the women had never been permitted to run long distances, so there was no data, which made it very easy to continue asserting things that data would have immediately disproved. The 19th century had produced a specific version of this anxiety around women and physical exertion. Upper-class women, in particular, were expected to be delicate. Exercise beyond light walking and gentle dancing was considered potentially damaging to the kind of refined femininity that the period valued. Working-class women, who performed hard physical labor every day of their lives and had no choice in the matter, were excluded from this concern entirely, which tells you the anxiety was not really about physiology. It was about class performance and the management of a very specific kind of female body. By the mid-20th century, the arguments had shifted but not disappeared. Women were permitted to run shorter distances in Olympic competition. 800 meters was introduced in 1928, removed after the 1928 Games, on the grounds that some competitors appeared distressed at the finish line and not reinstated until 1960. The women at the finish line of the 800 meters in 1928 who appeared distressed had just run hard in competition. This is what running hard looks like. The officials observing them appear to have expected something else, and when they didn't get it, they cancelled the event. Roberta Gibb ran the Boston Marathon in 1966 without a number, hiding in the bushes near the start and joining the race after it began, because she had applied for entry and been told that women were physiologically incapable of running the distance and therefore could not be admitted. She ran the entire course and finished ahead of more than 2/3 of the male runners. The Boston Athletic Association's response was not to admit women. It was to note that she had not officially raced and therefore had not officially finished. Catherine Switzer's entry the following year, complete with a bib number and a race official trying to remove her physically from the course, is the version that became iconic, partly because a photographer captured the official grabbing her jacket while she ran, producing an image that made the argument without requiring any additional text. Women's long-distance running at the Olympics did not include the marathon until 1984. The first women's Olympic marathon was won by Joan Benoit in Los Angeles, in a time that would have won the men's event in every Olympic marathon before 1952. The uterus survived. The inability to speak in court on your own behalf is, if you think about it carefully, a fairly complete form of erasure, and for much of history it was simply the legal default for women. Under English common law, a married woman's legal voice belonged to her husband. He spoke for her in court because she, legally, was him, or at least part of him, or at least not him in any legally meaningful sense. A woman who had been wronged could not bring a case. A woman who was accused could not defend herself independently. In cases where her interests directly conflicted with her husband's, there was no mechanism to represent those interests separately because the law did not recognize them as separate. The history of women gaining the right to testify, to sue, to be represented independently in court, and eventually to sit in judgment of others is a history of each of those rights being extracted from the legal system incrementally against resistance across roughly 2 centuries. Coverture, which you've already met, was the legal doctrine that made this possible. But the silencing of women in legal proceedings had roots older than coverture's formal codification. It connected to a broader principle, present across multiple legal traditions, that female testimony was inherently less reliable than male testimony. In early Roman law, women were among the categories of people considered incompetent to testify, alongside children, slaves, and convicted criminals, on the basis that they lacked the civic standing required to give credible evidence. The reasoning was circular in the familiar way. Women lacked civic standing because the law did not grant it to them, and the law did not grant it to them because they lacked it. In medieval English courts, women could testify in certain limited circumstances, particularly in cases involving other women, or in matters where no male witness was available. But their testimony was weighted differently, required corroboration that male testimony did not, and was subject to challenge on the basis of their sex in ways that male testimony was not. A woman's word, in the legal context, was provisional in a way that a man's was not, and this was codified in procedural rules that made women's access to legal remedy genuinely harder, even when they technically had access at all. The situations this produced were not abstract. A woman whose husband beat her had no independent legal standing to bring a case, because the case would have to be brought by her husband, the person she was bringing the case against. A woman whose property was taken had no standing to sue for its return if the person who took it was her husband. A woman who was defrauded in a business transaction had no standing to seek remedy unless a male relative brought the case on her behalf, introducing an intermediary whose interests were not necessarily aligned with hers and who had the power to decide whether to proceed. The reforms arrived in the form of Married Women's Property Acts in various jurisdictions across the second half of the 19th century, acts that are remarkable primarily for how recently they came and how limited they initially were. The right to testify in one's own criminal defense was established more gradually still, with different courts and jurisdictions moving at different speeds. The right to serve on a jury, to participate in legal judgment rather than simply being subject to it, came later still, and in some American states was not fully established until the Supreme Court intervened in the 1970s. The last piece is perhaps the most telling. A woman in many jurisdictions could testify, could sue, could be represented by her own counsel, but could not be judged by a jury that included people like her. The people deciding her fate, weighing her credibility, and applying the law to her situation were drawn from a pool that had been, by design, built without her. The system could hear her. It just wasn't required to understand her, and for most of legal history it didn't try. In medieval and early modern Europe, what you wore was not merely a fashion statement, but a legally regulated declaration of your social class, and women's dress was regulated with particular enthusiasm, not just for class reasons but for moral ones. Sumptuary laws dictated which fabrics, colours, and decorations were permissible for women of different ranks, with the explicit goal of making a woman's station legible at a glance. But the laws also targeted women specifically for wearing things considered above their station, for ornamentation considered too elaborate, for colours considered too bold. Red was restricted. Fur linings were ranked by status. Gold embroidery required a certain level of nobility. A merchant's wife who wore silk was a problem not because silk was inherently dangerous, but because it blurred the visual categories that kept everyone in their assigned place, and categories, in a feudal society, were doing a great deal of heavy lifting. Sumptuary laws appeared across Europe from the 13th century onward, and the English Parliament passed versions of them repeatedly between the 13th and 17th centuries, which tells you both how seriously they were taken and how thoroughly they were ignored, because laws that work don't need to be passed again every few decades. The specific provisions varied by time and place, but operated on a consistent principle. Your clothing should tell everyone who you were before you opened your mouth. and stepping outside your designated visual category was a form of social disorder that the state had an interest in correcting. Women were targeted more frequently and more specifically than men in the enforcement of these laws, for a reason that makes a particular kind of sense within the worldview producing them. Men's status was established through profession, title, landholding, and public role. Women's status was established largely through their relationship to men, as daughters, wives, and widows, and through their physical presentation. The garment was doing more of the identity work for women than for men, which meant the garment was more politically charged and more in need of legal management. The specific targeting of merchants' wives and women of the urban middle class across European sumptuary legislation reflects the anxiety of a hierarchical society watching economic change undermine visual order. As trade wealth grew and merchants became genuinely rich, the visual distinction between merchant families and noble families became harder to maintain without legislation. A merchant's wife who could afford velvet was going to buy velvet. The law's job was to tell her she couldn't. The law's job was also, repeatedly, not done. Enforcement was inconsistent, selective, and frequently applied to women in ways it was not applied to their husbands, which produced an interesting dynamic. A man could grow wealthy and spend freely, while his wife was legally required to dress below their actual means, making her appearance a kind of public display of regulated restraint. The wife, as walking advertisement for her husband's compliance with social norms, whether or not he personally complied. This pattern, women's bodies and clothing, as the site where social rules are most publicly performed and most rigorously enforced, runs through the sumptuary laws and well beyond them. By the 17th century, sumptuary laws were fading in England, replaced by the social pressure of fashion itself as a regulatory mechanism. What you wore was still enormously important. It was just no longer backed by statute. The informal version, it turned out, worked well enough on its own. The fear of being seen in the wrong thing, in the wrong company, at the wrong moment, was sufficient to keep most people legible to each other without requiring a magistrate. The cage changed materials. The dimensions stayed roughly the same. Until the mid-19th century in England and America, custody of children upon divorce went automatically to the father. Not because fathers were assumed to be better parents, but because children, like property, belonged to the husband's household, and divorce meant the wife left that household. She left alone. The Custody of Infants Act in England in 1839 represented a radical first concession. Women could apply for custody of children under 7. Under 7. Caroline Norton, who campaigned for the act after her husband took their children and refused her access, was not granted custody under the law she had helped create, because her husband cited her extramarital conduct as disqualifying. She had conducted her alleged affair with the Prime Minister, which did not help procedurally. The legal principle underlying paternal custody was not sentiment, it was property. Under coverture, a wife's legal existence was absorbed into her husband's, and children produced within the marriage were, in the most direct legal sense, his. They bore his name, lived under his authority, and represented continuity of his lineage and household. The wife had produced them, but production did not confer ownership in a system where the wife herself was not legally her own person. When she left the marriage, or when the marriage was dissolved, she was leaving his household, and everything in that household, including the children, remained. This meant that a woman leaving an abusive marriage left not only her home and financial security, but her children. The knowledge that divorce meant losing access to her children was an extraordinarily effective mechanism for keeping women in marriages they wished to leave, and it operated without requiring any explicit statement of that intent. The law did not have to say women must stay married to make leaving marriage catastrophic. It only had to say that leaving meant losing everything, and the math would take care of the rest. Caroline Norton's case is among the most documented because she was articulate, well-connected, and sufficiently enraged to write about it extensively. Her husband George Norton had beaten her throughout their marriage. This was legal, and when she sought to leave, he took their 3 sons and refused her any contact. He also sued the Prime Minister, Lord Melbourne, for criminal conversation with his wife, a legal action meaning adultery, which was a recognised cause of action in which the husband sued the man who had allegedly slept with his wife for damages, because the wife's fidelity was considered the husband's property. The case failed. George Norton got no damages. He kept the children anyway. Norton could not sue her husband for anything. She could not appear as a party in any legal proceeding. She could not retain the earnings from the writing she did to support herself, because under coverture her earnings were legally his. She wrote pamphlets, lobbied Parliament, corresponded with politicians, and produced one of the most effective advocacy campaigns for legal reform in Victorian England, while being legally classified as a non-person. The Custody of Infants Act passed in 1839 as a direct result of her efforts. She was not given custody of her children under it. Her youngest son died in a riding accident while in his father's care before she could see him again. The law improved from there, slowly, incrementally, through additional acts in 1873 and 1886 that raised the age threshold and broadened courts' discretion. American states moved at their own speeds. The legal presumption shifted over the 20th century toward the best interests of the child standard, which introduced judicial discretion without eliminating bias. What replaced the automatic father presumption was not automatic mother presumption, it was supposed to be neutral. Whether it was, in practice, is a question that family lawyers of the 20th century could address at length. Across numerous cultures and centuries, the prohibition on women in public space was not merely customary, but architectural, enforced by the design of homes, neighborhoods, and cities. The practice of purdah, observed in various forms across South Asia and parts of the Middle East, restricted women's movement outside the home and required that movement in public be conducted behind screens, curtains, or full covering. The domestic sphere was not just where women belonged. In many interpretations, it was the only space that could legitimately contain them. Women who moved through public space without appropriate male accompaniment were treated as making a statement with their bodies that they had not necessarily intended to make. The rules governing women's presence in outdoor, commercial, and civic space were among the most pervasive and varied forms of restriction across the historical record, so pervasive, in fact, that for much of history, the outside world was simply not a place where women were expected to appear. Purdah, the word derived from the Persian and Urdu for curtain or veil, describes not a single practice, but a cluster of related practices built around the same organizing principle: the separation of women from public, non-familial male space. The forms it took varied enormously by region, class, and period. In some households it meant women lived in a separate section of the home, the zenana, and did not appear in the areas where male guests were received. In others, it meant that movement outside the home required a covered palanquin or vehicle, so that the woman was in public space without being visible within it. In others, it meant the full veil and accompanying male guardian, the mahram, without whose presence a woman simply did not go out. The class dimension of purdah is important and frequently obscured. Strict purdah, as a practice of absolute seclusion, was, in most historical contexts, an upper-class phenomenon, not because the poor were more liberated, but because strict seclusion required the economic resources to sustain it. A wealthy household could afford to keep women entirely within the domestic sphere because servants and male family members handled all external transactions. Poor women had to work, trade, fetch water, tend animals, and move through public space to survive, and the rules bent accordingly. The strictest seclusion was often a status symbol, as much as a moral mandate, which is a pattern that appears repeatedly in the history of female restriction. The most extreme versions of confinement were signs of family wealth and respectability. The architectural expression of female seclusion is visible across multiple cultures and centuries. The Greek gynaeceum, the Roman women's quarters, the Turkish harem in its actual historical form rather than its fantasy version, the zenana of South Asian households, all of these were spatial solutions to the same perceived problem. Women's presence in mixed space was disruptive, dangerous, or improper. And therefore the most reliable fix was to build a world within a world where women could exist without their existence causing complications. The quality of that interior world varied enormously. For elite women in well-resourced households, the women's quarters could be comfortable, socially rich, and politically important. Intrigues, alliances, and significant decisions often passed through the women's spaces of powerful households precisely because those spaces were where powerful men's closest relationships lived. For women with fewer resources, seclusion was simply confinement. Restricted movement meant restricted access to markets, to social networks, to the information that circulated in public spaces, to the economic opportunities that required physical presence to access. The woman who could not appear at the market without an escort could not negotiate her own prices, could not build her own commercial relationships, could not move through the world as an independent economic agent. The restriction encoded and reinforced the dependency it claimed to be managing. The outside was dangerous for unaccompanied women, partly because the rules making unaccompanied women transgressive created the conditions in which their transgression invited consequence. The logic was, once again, self-sealing. Across many cultures and centuries, women's literacy was considered either unnecessary or actively dangerous, depending on how confident the people in charge felt on any given day. The unnecessary argument went like this: women's lives were domestic. Domestic work required no reading, and therefore educating women wasted resources better spent on men. The dangerous argument went differently. A literate woman could read letters, keep her own accounts, correspond with people her husband didn't know about, and potentially encounter ideas. And ideas, in a woman, had a tendency to produce opinions, and opinions produced arguments, and arguments were exhausting. Some religious traditions specifically barred women from studying religious texts on the grounds that interpretation was a male domain. The practical result was that for most of recorded history, the majority of women in the world could not read, which made every other restriction significantly easier to maintain. The literacy gap between men and women across most of recorded history was not a natural phenomenon. It was produced by specific decisions made by specific institutions over extended periods of time. Schools, where they existed, admitted boys. Religious education, which was often the primary route to literacy in societies where the church controlled education, was directed at those who would serve the church, which meant men. The texts considered worth reading were written in Latin or Greek, languages taught only in institutions women could not attend. The illiteracy of women was engineered and then presented as evidence that women were not suited to learning. The dangerous knowledge argument had many specific forms. In early modern Europe, a woman who could read had access to religious texts she might interpret independently. The Protestant Reformation's emphasis on individual Bible reading created a genuine theological problem for those who believed women's spiritual lives should be managed by male clergy. A woman who could read could also read books that were not religious, including works on philosophy, natural science, and politics that were considered unsuitable for female minds, either because they were too complex or because they contained ideas that might encourage a woman to question her circumstances. The category of unsuitable reading for women expanded conveniently to include anything that might make them less willing to occupy the position assigned to them. In Japan, during the Heian period, the situation produced one of history's more interesting inversions. Classical Chinese, the language of official discourse and high culture, was considered a male domain. Women were not taught it and were not expected to use it publicly. Japanese vernacular writing, kana, was considered less prestigious and more appropriate for women's personal expression. The result was that women of the Heian court, writing in kana rather than classical Chinese, produced some of the greatest literature of the period. The Tale of Genji, the Pillow Book, while the men around them wrote official documents in a language they had been taught at the expense of the vernacular that would prove more lasting. The restriction created the conditions for its own circumvention, as restrictions on women's expression tend to do. Mary Wollstonecraft, writing in 1792, identified the literacy restriction as foundational to every other inequality she was arguing against. If women were educated as men were educated, she argued, they would prove themselves equally capable of reason, and the entire edifice of justification for their subordination would collapse. The response to this argument was not to disprove it. It was to continue not educating women and to cite their lack of education as evidence that the argument was wrong. That particular loop ran for another 2 centuries before it fully closed, and in parts of the world it has not closed yet. For most of Western legal history, divorce was something that happened to women, not something they could initiate. A husband could divorce his wife for adultery. A wife could divorce her husband for adultery, plus a list of additional grievances that grew longer and more specific with each century, because the law recognized, in its slow way, that if you were going to make something technically possible, you had to also make it practically impossible. In England, before the Divorce and Matrimonial Causes Act of 1857, divorce required a private act of Parliament, which was expensive, slow, and available to almost no one. After the act, women could divorce for adultery combined with cruelty, incest, bigamy, or desertion, while men could divorce for adultery alone. The principle was stated openly: men's infidelity was a personal failing, women's was a social crisis. The asymmetry was not accidental and was not hidden. Judges and legislators who were asked to explain it explained it. A wife's adultery was a greater offence than a husband's, because a wife's adultery introduced the possibility of illegitimate children into the husband's household. Children he might unknowingly raise as his own, who might inherit his property and his name. A husband's adultery introduced no such complication. His illegitimate children, if any, were someone else's problem. The law, in other words, was protecting property transmission, not sanctity of marriage, and it was doing so by encoding a double standard that would have been embarrassing to state plainly if anyone had been in the habit of stating things plainly. The practical consequences of this asymmetry fell entirely on women. A woman trapped in a marriage with a cruel, unfaithful, or abusive husband could not leave without losing her financial security, her children, and her social standing. And even if she managed to navigate all of that, she could not legally remarry unless she could prove grounds that satisfied the court's escalating requirements. A man in an unhappy marriage could simply wait, or he could find grounds, and in a system where his wife's conduct was more closely scrutinized than his own, grounds were not always hard to manufacture. The women who did manage to divorce in the period before legislative reform are mostly known because their cases were sensational enough to be recorded. Lady Diana Beauclerk divorced her husband in 1768 in a case that required an Act of Parliament and cost more than most people earned in a lifetime. Eleanor Gwynne, not that one, various women of rank who could afford the legal mechanism and had the social connections to navigate it. They exist in the historical record precisely because they were exceptional. The ordinary woman in an ordinary terrible marriage had no legal exit. The 1857 Act was transformative but limited. Divorce moved to a new civil court rather than Parliament, making it technically accessible to people who were not aristocrats. The double standard in grounds remained. The social consequences of divorce fell far more heavily on women than on men. A divorced woman was socially compromised in ways a divorced man was not, which meant that even as the legal option became available, the practical cost of using it remained prohibitive for most women. The law opened a door. Society put a significant amount of furniture in front of it. No-fault divorce, the version of divorce law that allows a marriage to be dissolved because it has irretrievably broken down, rather than because one party has committed a specific legal offense. He arrived in California in 1969 and spread through American states across the following decade. Its arrival was accompanied by warnings that it would destroy marriage as an institution. The divorce rate rose, marriage rates over the longer term stabilized, the institution survived. The women who had previously been unable to leave marriages they could not legally prove were bad enough simply had somewhere to go, which is the part of the story the warnings tended to leave out. The opening of Oxford and Cambridge to women is a story that proceeds in such small increments that each individual step looks almost generous until you look at the timeline. Women were permitted to attend lectures at Cambridge from the 1860s. They were permitted to sit examinations. They passed. They were not, however, awarded degrees, because a degree would imply membership in the university, and membership would imply equality, and equality was a bridge too far. Cambridge did not award degrees to women until 1948. Oxford managed it slightly earlier, in 1920. Harvard's medical school did not admit women until 1945. The specific arguments varied by institution and decade, but the structure was consistent. Women could get close enough to see what they were missing, just not close enough to actually have it. The women's colleges that formed around Oxford and Cambridge in the 19th century, Girton, Newnham, Somerville, Lady Margaret Hall, were not inferior institutions. They were, in many cases, exceptionally rigorous, because the women who ran them understood that the case for women's education was being tested in public, and any failure would be used as evidence for the general argument. Philippa Fawcett, at Newnham College, placed above the senior wrangler in the Cambridge Mathematical Tripos in 1890, the highest score in the year, in a notoriously difficult examination, achieved by a woman who would not be awarded a degree. The result was announced publicly. The student body of Cambridge responded with outrage, protests, and in some cases with significant property damage. The outrage was not directed at the exam system, it was directed at the woman who had scored highest on it. The specific argument made against awarding degrees to women who had completed degree-level work was not always clearly articulated, which suggests it was more instinct than reasoning. The articulated versions included: women would distract male students from their studies. The presence of women would lower the social prestige of the degree. Women's intellectual achievement, while occasionally impressive, was qualitatively different from men's, in ways that the examination results admittedly did not capture, but that everyone instinctively understood. This last argument is among the more creative in the historical record, a claim that women were different in ways that tests couldn't measure, deployed precisely at the moment when the tests had measured them as equal. In America, the women's colleges of the Northeast, Vassar, Wellesley, Smith, Mount Holyoke, Radcliffe, Bryn Mawr, operated on a similar principle. If the existing institutions would not open, build parallel institutions of equivalent or better quality. The Seven Sisters produced graduates who went on to careers in law, medicine, science, and government, while the institutions that had refused to admit them gradually, over decades, came around. Radcliffe College was formally merged with Harvard in 1999, meaning that Harvard spent 163 years of its existence as a male institution before concluding the experiment was worth revising. The deeper damage of the exclusion was not the specific degrees that were not awarded, it was the networks, the credentials, the institutional affiliations that opened professional doors in subsequent decades. A Harvard degree in 1920 was not just an education, it was access to legal firms, to medical institutions, to government positions, to social circles where decisions were made. Keeping women out of the degree was keeping them out of all of that, and the downstream effects accumulated over generations in ways that neither the individual exclusions nor the eventual admissions fully account for. You can open the door in 1948. The people who were kept out of the building in 1920 still didn't get in. At various points in history, women's use of cosmetics has been legally regulated, morally condemned, and associated with everything from prostitution to witchcraft, depending on how alarmed the authorities felt and what they needed cosmetics to mean in that particular moment. In 17th century England, a bill was proposed in Parliament. It did not pass, but it was proposed that would have allowed marriages to be annulled if a woman had used cosmetics, perfume, or false hair to deceive a man into marrying her on the grounds that this constituted a form of fraud. The logic was that a man's property rights in a wife included rights to her unimproved appearance. In Puritan New England, face paints were associated with vanity and moral corruption. In many cultures, visible cosmetics marked a woman as available in ways she might not have intended, attaching meaning to her face that she had not chosen to put there. The use of cosmetics by women has a history at least as old as recorded civilization. Egyptian women used coal and red ochre, Roman women used lead-based face whiteners that were slowly poisoning them, and Elizabethan women applied ceruse, a white lead paste, in quantities sufficient to cause genuine medical damage over time. The existence of the practice was not the issue. The issue was who was doing it, in what context, with what effect on their perceived moral character. Cosmetics used privately, in service of appearing naturally more attractive to a husband, were generally tolerated. Cosmetics used publicly, in ways that enhanced a woman's appeal to people generally, were the problem, because a woman making herself appealing to people generally was a woman operating in public space on her own terms, and that carried implications. The English Parliament Bill of the 1600s proposed that cosmetic enhancement constituted the same category of fraud as misrepresenting property in a sale, which is revealing in ways its authors may not have intended. The underlying assumption is that the husband was acquiring something in marriage, a woman's appearance among other things, and that acquiring it under false pretenses constituted a legal injury. The woman's face as a commodity whose quality could be misrepresented, the woman as the party engaged in commercial deception, the husband as the party whose interests the law protected. None of this was considered remarkable at the time, which is itself remarkable. The association between cosmetics and prostitution runs through the regulatory history of cosmetics in ways that were sometimes explicit and sometimes merely implied. In some medieval European cities, prostitutes were required to wear particular garments or markings to make their status visible, and the prohibitions on cosmetics for respectable women were partly designed to maintain the visual distinction between categories of women. A respectable woman who wore visible cosmetics was blurring a line the law had an interest in keeping sharp. The line's sharpness protected the respectable women's reputation and the regulatory categories that managed women's sexuality. A woman who looked like she might be either was administratively inconvenient. The 20th century's cosmetics industry, which turned cosmetic use into a mass market practice available to women at every income level, did not eliminate the moral freight around cosmetics. It redistributed it. Wearing too much became vulgar, wearing too little became careless. The correct amount was subjective and socially enforced and shifted with the decade. The regulation moved from statute to social pressure, which as always did a great deal of the same work with considerably less paperwork. You could now legally wear whatever you wanted on your face. Whether you would be judged for it was, and remains, a separate question. The arguments made against women's suffrage were many, varied, and delivered with the complete confidence of people who had not thought them through. Women were too emotional to vote rationally. Women were too sheltered to understand politics. Women were already represented by their husbands, making a separate vote redundant. Women who wanted to vote were unwomanly, and women who were unwomanly were dangerous, and danger was reason enough. The vote, it was said repeatedly, would destroy the family, not because voting took very long, but because a woman with a political opinion was a woman who might have other opinions. And that had a tendency to snowball. New Zealand became the first country to grant women the right to vote in 1893. Switzerland, often held up as a model of democratic order, did not grant women the right to vote in federal elections until 1971. 1971. The arguments against women's suffrage were not confined to obvious reactionaries. They came from sitting prime ministers, from doctors who testified before Parliament about the physiological unsuitability of women for civic participation, from women's organisations explicitly formed to oppose suffrage, and from journalists who covered the suffrage movement with a combination of mockery and genuine alarm. The breadth of the opposition is worth sitting with, because it suggests the arguments were not really about voting. Voting takes minutes. The arguments against it lasted decades. What was actually at stake was the principle that women's participation in public life was legitimate, and that principle, once conceded in one domain, was going to be very difficult to contain. The virtual representation argument, that women were already represented through their husbands and fathers and therefore did not need a separate vote, had been deployed earlier against working-class men who didn't own property and against the American colonists before the Revolution. It was an argument with a useful flexibility. It could be applied to any group whose exclusion needed justifying without ever having to name the actual reason. The actual reason, in each case, was that including them would shift the balance of power, and the people with the power preferred the existing balance. Virtual representation was just the polite version of saying, we'd rather not. The anti-suffrage women's organisations deserve particular attention because they are often treated as an anomaly, women opposing their own rights, when in fact they make a consistent kind of sense within the period's logic. Many of the women who organised against suffrage were women of the upper and middle classes who had achieved significant social influence through the existing system, through charitable work, through moral authority, through the protected sphere of domestic life, as a domain where their voices carried weight. Suffrage threatened to dissolve the separate sphere that granted them that influence, replacing it with direct political participation in which they had no existing advantage and no guaranteed standing. They were not confused about their interests. They were defending a different set of them. The suffrage campaigns across Britain and America took forms that ranged from the decorous to the spectacular. In Britain, the suffragettes of the Women's Social and Political Union, led by Emmeline Pankhurst, escalated from petitions to demonstrations to window smashing to arson to hunger strikes in prison, where they were force-fed through tubes in a process their doctors described as medical treatment and their supporters described more accurately. Emily Wilding Davison walked onto the Epsom Derby course during the race in 1913 and was struck by the King's horse and killed. Whether this was intentional or an attempt to attach a suffrage banner to the horse that went wrong remains debated. The image was on front pages across the world. The 19th Amendment to the United States Constitution was ratified in 1920. The last American state to ratify it formally was Mississippi in 1984, 64 years after it had already become law. They got there eventually. In medieval Europe and in many cultures well beyond it, land passed from father to son and then from son to son, skipping daughters as though they were a clerical error in the family ledger. A woman might live her entire life on land her family had farmed for generations, and upon her father's death, it would pass to the nearest male relative, a brother, an uncle, a distant cousin who had never set foot on the property, while she was expected to accept this arrangement with grace. In England, primogeniture gave everything to the eldest son, and entail could lock land away from daughters even when no male heir existed. A legal mechanism immortalized in literature precisely because it drove so many actual women to the edge of ruin. A daughter could be sharp, capable, experienced and devoted, and still watch everything she'd known disappear into the hands of a man she'd never met. Because the law had decided that ownership was a masculine noun, land was not merely property in the medieval and early modern world. It was identity, security, political standing, and social power consolidated into acres. To own land was to have a stake in the society that land sustained, to have a vote in later periods, in the governance of the locality, to have standing in legal disputes, to have something that could be inherited, borrowed against, and defended. The exclusion of women from land inheritance was therefore not merely an economic deprivation. It was a systematic exclusion from every form of power that land underwrote. You could not have political standing without land. Women could not have land. Therefore, women could not have political standing. The logic was airtight because it was circular, and it was circular by design. The entail, which features so prominently in novels of the period because it featured so prominently in the lives of the women reading them, was a legal device that restricted land inheritance to a specific line of heirs, typically male heirs, regardless of whether suitable male heirs existed or were competent to manage the estate. The Bennet family's predicament in Pride and Prejudice is not a literary invention. It is a direct representation of a legal reality that affected thousands of families across England, in which a father could not leave his estate to his daughters no matter how capable they were, and no matter how unsuitable the male heir who would receive it. Jane Austen wrote about it because she lived near it. Many women lived inside it. The Salic law, applied across much of continental Europe with varying interpretations, excluded women from succession to the throne on the same principle: land, including the land that constituted a kingdom, passed through the male line. This produced genuinely strange outcomes when male lines ran out, including the 100 Years' War, which was in significant part a dispute about whether the French crown could pass through a female line to the English king, and which killed enormous numbers of people over a question that would have been resolved differently if the law had been written differently several generations earlier. Women who did inherit, usually in the absence of male heirs, or through specific legal arrangements made in advance, often found that inheritance was complicated by the expectation that they would marry, at which point the inherited property became their husband's under coverture. The daughter who inherited her father's estate in the absence of male heirs brought that estate into her marriage, and it left her control at the altar. The inheritance passed to her as a way station on its journey to the next man in line, which was an efficient system if you were the next man in line. The slow dismantling of inheritance law's male preference across the 19th and 20th centuries happened unevenly, jurisdiction by jurisdiction, with particular resistance in contexts where land was also tied to political representation. Equal inheritance rights in English law arrived formally in the mid-20th century. In some parts of the world, the preference for male heirs in property transmission remains legally or customarily embedded, which means the argument being made by those medieval land laws is still being made, just with updated paperwork. For centuries, respectable women were expected to ride horses side saddle, both legs on the same side, body twisted slightly, balanced on a seat not designed for actual riding, so much as for the performance of appearing to ride while remaining in an acceptable physical configuration. Riding astride, the way men rode, was considered immodest, sexually suggestive, and potentially damaging to a woman's reproductive health, a concern that was applied to a remarkable variety of female activities whenever the actual reason for banning them was too embarrassing to state plainly. Side saddle riding was genuinely dangerous. Women fell more easily, had less control, and could not respond as quickly in difficult terrain. None of this outweighed the optics. Women who rode astride in the 19th century were written about in newspapers as if they had done something alarming, which they had, just not in the way the newspapers meant. The side saddle itself was not ancient. Women in the early medieval period rode astride without significant cultural controversy, and side saddle appears to have developed in the late medieval period partly for practical reasons. Heavy skirts made astride riding genuinely uncomfortable, and partly as a visual convention that marked elite women's riding as a performance of status rather than a functional activity. The queen rode side saddle. Therefore side saddle was what queens did. Therefore side saddle was what respectable women did. Therefore astride was something else entirely, and something else entirely was the problem. The modesty argument was specific and worth examining. Riding astride required a woman to part her legs around the horse, which was considered an immodest posture, regardless of the layers of skirt and petticoat between her and any observer. The issue was not actual visibility. The issue was the shape made by the body in that position, a shape that was categorized as sexually suggestive in a cultural vocabulary that had decided female bodies in certain configurations were inherently available for interpretation, regardless of what the woman attached to the body was. Actually doing. She was riding a horse. The position in which she did so was, apparently, communicating something independently of her intentions. The reproductive health argument was deployed with the same confidence that attended most medical arguments against women's physical autonomy in the 19th century, which is to say with no supporting evidence and a great deal of professional authority. Riding astride, it was claimed, could damage the uterus, disrupt the organs, and compromise a woman's capacity for childbearing. Doctors who made this claim had not studied women riding astride, because women were not riding astride, so there was no data, which left the claim floating in the comfortable space between assertion and disproof that was the natural habitat of 19th century medical opinions about women's bodies. Western women, living in frontier and rural environments, frequently ignored the convention entirely, because ignoring it was the difference between being able to move across difficult terrain and not being able to. And when the choice was between propriety and getting somewhere, the practical considerations generally won. Cowgirls, ranch women, and women who worked with horses professionally rode astride with the matter-of-fact practicality of people whose horses were tools rather than accessories. Their doing so was noted in the press with a combination of fascination and mild disapproval that was the standard register for women doing things efficiently without male supervision. The divided skirt and eventually the riding trouser resolved the practical side of the question in the late 19th century, and the 20th century's shifting dress conventions removed most of the remaining resistance. By the time women began competing in Olympic equestrian events, first permitted in 1952 for dressage only, with full equestrian competition including jumping opening to women in 1964, nobody seriously argued that the horse would cause a problem. The horse, for its part, had never had an opinion on the matter and had been waiting patiently for everyone to work it out. In the name of protecting women, various countries and states throughout the 19th and early 20th centuries passed legislation explicitly banning women from working night shifts in factories and certain other industries. The protection was real, in one narrow sense. Night factory work was genuinely brutal, but the protection was also extraordinarily selective. Women could work nights as domestic servants, nurses, laundresses, and in any number of jobs considered appropriately feminine. The restriction applied specifically to industrial work, which paid more, offered more independence, and was therefore more in need of being kept from women. When women pointed this out, they were told they were confused about what was good for them, which was a response that also did not age well. The night work prohibitions developed from a genuine problem and arrived at a deeply convenient solution. Factory work in the 19th century was often dangerous, exhausting, and conducted in conditions that caused lasting physical harm to everyone who performed it regardless of sex. The early labor movement, which was largely male-organized and male-led, had a particular interest in limiting women's participation in industrial labor, not purely from protective impulse, but because women's willingness to accept lower wages undercut men's ability to demand higher ones. Protective legislation that kept women out of the higher-paying shifts was protective in the way a fence around a garden is protective. It kept certain things out, but the things kept out were the ones with reason to want to get in. The International Labour Organization, founded in 1919, adopted a convention on women's night work that year and maintained versions of it for decades, recommending that member states prohibit women from industrial night work in a framework that was presented as a universal labour standard. Women workers in affected industries repeatedly objected that the protection removed their access to shift differentials, overtime pay, and positions that required night availability. They were told that their health and their families required the protection. The possibility that women might be in a better position than international labour bodies to assess their own health and family needs was not prominently featured in these discussions. The selectivity of the protections was impossible to ignore once you looked at it directly. The nurse, working a 12-hour overnight shift in a hospital, was not covered by night work prohibitions. The domestic servant sleeping in her employer's house and expected to be available at any hour was not covered. The female factory worker seeking to earn the shift premium that her male colleague earned for the same hours was the person the law was protecting. The protection had a very specific shape, and the shape was the outline of the better-paying jobs. In the United States, the Supreme Court upheld an Oregon law limiting women's working hours in Muller v. Oregon in 1908, in a decision that relied heavily on arguments about women's physical fragility and their special role as mothers. Arguments that were used not only to justify the specific limitation at issue, but to establish a general principle that women's employment could be regulated in ways that men's could not. The decision was cited for decades as precedent. It protected some women from some forms of exploitation. It also established that women were a legally distinct class of worker whose access to employment could be limited by the state on the basis of their sex, which was a principle that cut in multiple directions depending on who was wielding it. The prohibitions were largely dismantled in the latter half of the 20th century under pressure from anti-discrimination law and from women workers who had spent decades pointing out what the protection was actually protecting. The argument that women needed to be kept away from night work for their own good had lasted about as long as the people making it could keep straight faces. In a number of cultures across history and geography, married women were prohibited from speaking their husband's name, not as a term of affection but as a form of social control. So internalized it eventually just looked like politeness. In parts of West Africa, women used elaborate circumlocutions to avoid naming their husbands directly, referring to them by title, relationship, or description instead. In ancient China, a wife addressing her husband by name was considered disrespectful to a degree that had legal and social consequences. In Victorian England, the convention of referring to a husband as Mr. So-and-so and never by given name in public was less a legal prohibition than a social one, but social prohibitions enforced by community pressure have always done a great deal of the work that laws were eventually asked to formalize. The name taboo is among the more intimate forms of restriction in the historical record, precisely because it operated at the level of speech itself, not what a woman could do or where she could go, or what she could own, but what she could say, what sounds she was permitted to make, what words could come out of her mouth in the ordinary flow of daily conversation. It required constant self-monitoring. Every sentence that might include the husband's name had to be constructed around the gap where the name would have been, which made the taboo present in every interaction a permanent low-level reminder of the hierarchy being maintained. In the Zulu naming traditions of southern Africa, A practice called halonifer required women, particularly new brides, to avoid not only their husband's name but any word that sounded similar to it, any word containing the same syllables, and in some interpretations any word associated with his family members' names as well. This meant a new bride might need to construct an entirely new vocabulary for objects and concepts whose normal names had been rendered unspeakable by proximity to her husband's name. Anthropologists documenting the practice in the 19th and 20th centuries noted that it produced, over time, genuinely distinct female speech patterns. Women's language and men's language diverged in vocabulary because women had been required to root around a significant portion of the available words. The Victorian convention of wives referring to husbands in public by title and surname, rather than given name, operated more subtly but toward the same end. A wife who called her husband by his first name in mixed company was considered inappropriately familiar. The intimacy of first names was for private use, and performing that intimacy publicly suggested a presumption of equality that the social code found unseemly. The correct form reinforced the public understanding of the relationship. She was Mrs. His name, he was Mr. His name, and the asymmetry was visible in every introduction. She had, in marrying him, taken his name. He had given her nothing but the title of the person attached to his name. The name taboo connects to a broader pattern in which women's relationship to language was managed as a form of status maintenance. Women's speech was regulated. Too much of it was a legal offence, as we have already seen, and certain kinds of it were prohibited in religious settings. The specific regulation of the husband's name is a particularly direct version of this. Not how much she spoke or where she spoke, but what she was permitted to name. To name something is, in many cultural and linguistic traditions, a form of power over it, to summon it, to claim familiarity with it, to establish a relationship to it through language. The prohibition on naming the husband was a prohibition on that form of power, extended across every conversation for the entire duration of the marriage. It dressed itself as deference and functioned as erasure. Across much of the 19th and 20th centuries, pregnancy was treated by employers as a voluntary resignation letter because a visibly pregnant woman at work suggested that a woman had a body, and a body suggested she had a life outside the office, and that was apparently disruptive. Teachers in the United States were routinely fired upon becoming pregnant well into the 1960s because a pregnant teacher was considered inappropriate for children to see, the logic being that children might thereby learn that their teachers were human. Airline stewardesses, as they were then called, were fired for becoming pregnant, for getting married, or for exceeding weight limits that were not applied to their male colleagues. The Pregnancy Discrimination Act was not passed until 1978. Before that, losing your job for being pregnant was not discrimination. It was just Tuesday. The firing of pregnant women from professional positions was so normalized for so long that it operated without requiring explicit policy in many workplaces. A woman who became pregnant understood, from the culture around her, that she was expected to leave. Colleagues expected it, supervisors expected it, and the woman herself often expected it, having grown up in a world where this was what happened. The expectation was self-enforcing in ways that made the discrimination harder to identify and challenge. If everyone behaves as if a thing is inevitable, the inevitability looks like nature rather than policy, and nature is much harder to take to court than policy. The teaching profession provides the clearest documentation because the enforcement was explicit and institutionalized. School boards across America had written policies requiring female teachers to resign upon marriage, and separate policies requiring those who had married to resign upon becoming pregnant. The rationale offered varied. Pregnant teachers were visually inappropriate for children, they were unreliable due to upcoming absence, their domestic situation now made them less committed professionals. The actual rationale, less frequently articulated, was that teaching was considered a vocation requiring a certain kind of femininity, dedicated, unmarried, celibate, in practice, if not in law, and pregnancy visibly contradicted that construction. A pregnant teacher was a teacher who had had sex, and that was distracting in a way that a pregnant student apparently was not. The airline industry developed its own version of this with extraordinary specificity. Flight attendants, uniformly female until the late 1960s, required to maintain specific weight and appearance standards, required to be unmarried, and required to resign at a specific age, were subject to a set of employment conditions that read, in retrospect, as a masterclass in treating women's bodies as the product being sold rather than the labour doing the work. Stewardesses were fired for gaining weight. They were fired for marrying. They were fired for turning 32 or 35 or whatever age the airline had decided was the boundary of the appealing femininity, the ticket price included. Pregnancy was simply the most visible version of the same principle. The body had changed in a way that the employer considered unacceptable, and the employer's opinion of the body was the operative factor. The legal change came from two directions simultaneously in the 1970s. The Equal Employment Opportunity Commission issued guidelines interpreting pregnancy discrimination as sex discrimination under the Civil Rights Act of 1964. And then, in 1978, Congress passed the Pregnancy Discrimination Act to make the point explicitly. After a Supreme Court decision had found that pregnancy discrimination was not sex discrimination because men and women were equally subject to it, equally subject to being fired for being pregnant, which is the kind of reasoning that produces landmark legislation in response. The Act required employers to treat pregnancy the same way they treated any other temporary physical condition affecting an employee's ability to work. That this required a federal statute to establish tells you everything you need to know about what the default had been. It sounds invented. It was not. In various cultural and historical contexts, women laughing visibly and audibly in public was considered immodest, unladylike, and in certain settings genuinely transgressive. In 18th and 19th century conduct manuals, women were advised to smile rather than laugh, to keep any amusement small and contained, and under no circumstances to open their mouths wide enough that their teeth showed, because a woman with her mouth fully open was communicating something beyond delight. In Japan, during certain historical periods, court women covered their mouths when they smiled. In some Middle Eastern traditions, a woman's laughter in mixed company was read as a form of public intimacy that violated social codes. The underlying principle was consistent across contexts. A woman who laughed loudly and freely was a woman who was not performing the right kind of self-erasure. The conduct manual is one of the more reliable guides to what a period found threatening in women, because conduct manuals exist to suppress things that are actually happening. Nobody writes extensive instructions about how women should not laugh if women are not laughing. The frequency and specificity of the instructions around laughter across several centuries of European conduct literature suggest that women were laughing regularly and enthusiastically, and that this was causing genuine discomfort to the people who wrote the manuals, which is objectively a satisfying thing to know. The specific instruction to smile rather than laugh connects to a broader aesthetic of controlled female expression that ran through elite culture in particular from the Renaissance onward. A smile was legible and manageable. It indicated pleasure without suggesting abandon. It could be held in the face without the body being involved. It communicated warmth while maintaining the stillness that was associated with dignity and virtue. A laugh was something else. It involved the body. It was often involuntary. It produced sound that could not be precisely calibrated, and it frequently arrived in response to things that were funny rather than in response to things that were socially appropriate. The uncontrolled laugh was the problem. The laugh that arrived before the woman could decide whether to permit it was the laugh that needed to be trained out of her. The Japanese practice of covering the mouth while smiling or laughing, particularly associated with women of the Heian and subsequent court periods, is sometimes described as purely aesthetic. White teeth against dark clothing in candlelit interiors, and so on. But it also operated as a management of expression, a way of making pleasure less visible, less direct, less available to the room. The hand over the mouth is both a physical gesture and a social one, and its persistence across several hundred years of Japanese court culture tells you it was doing more work than aesthetics alone required. Laughter as a social act is always relational. It responds to something. It invites others in. It presupposes a shared understanding of what is funny, and it creates a brief community between the people laughing together. A woman who laughed publicly was participating in exactly this kind of social creation. She was responding to the world, asserting her own perspective on what was funny, and inviting others to share it. This is, when you spell it out, a form of self-expression and social agency, and those were precisely the things that the conduct manual was designed to regulate. The laugh was not the problem. The self it expressed was. There is a specific instruction that recurs across multiple cultures and centuries, advising women that, should laughter prove unavoidable, it should be directed downward rather than outward, eyes cast down, head slightly bowed, the laugh contained within the self rather than released into the room. The woman who laughed downward was, in the spatial metaphor of the instruction, laughing at herself rather than at the world. The difference between those two directions is, it turns out, the whole argument. Across numerous cultures and centuries, the prohibition on women in public space was not merely customary, but architectural, enforced by the design of homes, neighborhoods, and cities. The practice of purdah, observed in various forms across South Asia and parts of the Middle East, restricted women's movement outside the home and required that movement in public be conducted behind screens, curtains, or full covering. The domestic sphere was not just where women belonged. In many interpretations, it was the only space that could legitimately contain them. Women who moved through public space without appropriate male accompaniment were treated as making a statement with their bodies that they had not necessarily intended to make. The rules governing women's presence in outdoor, commercial, and civic space were among the most pervasive and varied forms of restriction across the historical record. So pervasive, in fact, that for much of history the outside world was simply not a place where women were expected to appear. In the United States, a married woman could not obtain a passport in her own name without her husband's permission until 1978, not 1778. 1978, the year the Bee Gees were at the top of the charts, the year the first test tube baby was born, the year the Camp David Accords were signed. A married American woman who wished to travel internationally as an independent adult required her husband's written consent to be issued a document certifying that she was who she said she was. Without his signature, she did not officially exist at a border. She traveled, if she traveled at all, as a dependent listed on his passport, a rider on his identity, her name in parentheses after his as though she were a footnote in the story of someone else's life. The passport restriction was one of dozens of ways in which the apparatus of daily civic life was constructed around the assumption that married women moved through the world as extensions of their husbands rather than as individuals. The assumption was so thoroughly embedded in the administrative infrastructure that it was often invisible until someone tried to do something without it, which is the characteristic feature of systemic exclusion, that it looks like the natural order until the moment it requires active enforcement. The practical implications of travelling on a husband's passport were not trivial. A woman travelling alone while listed as a dependent on her husband's document was in a genuinely ambiguous position at every border crossing. She had a document, but the document was not quite hers. And the nature of its not quite hersness depended on the discretion of the official at the crossing. If something went wrong abroad, a medical emergency, a legal problem, a need to leave quickly, her options were circumscribed in ways that a man in the same situation did not experience. She was travelling on borrowed identity, which is a poetic way of saying she was legally not fully herself in another country. The requirement for a husband's permission extended to the application process itself. A married woman applying for her own passport, which was, in some periods, technically possible even if practically difficult, needed documentation of her husband's consent as part of the application. This meant that a woman whose husband refused to give consent could not obtain a passport. A woman who was escaping her husband could not easily travel internationally to do it. A woman whose husband was abusive, controlling, or simply uncooperative had a travel restriction enforced not by border guards but by the passport office, which is a form of domestic control with a government letterhead. The international picture was, if anything, more varied and more restrictive than the American one. In many countries, a married woman's right to a passport, to retain her own nationality upon marriage, and to pass her nationality to her children, was restricted well into the latter half of the 20th century. A woman who married a foreign national in many jurisdictions automatically lost her own citizenship, became stateless, or became a citizen of her husband's country, whether she wished to or not, because nationality, like so many other things, was considered a status that passed through the male line. Saudi Arabia maintained a male guardianship system, mahram, under which women required a male guardian's permission to obtain a passport and travel until reforms began in 2019. The specific reform was noted internationally as a significant change. It was also noted that the guardian's permission was still required for marriage and for certain other legal actions, which means the reform was real and partial at the same time, which is the characteristic pace of these changes across every culture and every century: real, meaningful, and not yet finished. The document certifying that a woman is herself, issued by her government, requiring a man's signature for her to obtain. It sounds like a detail. It is the whole argument, compressed into a form. The practice of a woman taking her husband's surname upon marriage is so familiar in much of the English-speaking world that it tends to be treated as custom rather than rule, something women choose rather than something women were long required to do, and something whose history of enforcement is worth examining more carefully than the comfortable framing of tradition typically allows. In England and America, a married woman who wished to keep her birth surname faced not merely social pressure, but legal obstacles that, until very recently in historical terms, made retaining her own name practically difficult and in some periods formally impossible. The name change was, for most of the period during which it was expected, not a choice. It was a consequence of coverture. The same doctrine that absorbed her legal identity into her husband's also absorbed her name, because the name was the identity, and the identity had become his. The mechanism was not a specific law requiring name change at marriage. It was subtler and in many ways more effective. The common law assumption that a married woman was known by her husband's name meant that all legal documents, contracts, property records, and official correspondence used his name for both of them. A woman who attempted to maintain her birth name in legal and official contexts found that the documents did not cooperate. Banks processed paperwork in the married name, courts referred to her by the married name, and official records that needed to track a continuous identity across time used the married name because that was the identity the system recognized. Lucy Stone, the American abolitionist and suffragist, kept her birth name upon marrying Henry Blackwell in 1855 and spent years navigating the administrative resistance that followed. She could not vote in her own name, hold property in her own name without legal complication, or operate in official contexts without encountering a system that had been built to accommodate married women only under their husband's name. She became famous enough that women who kept their birth names after marriage for the next century were called Lucy Stoners, a tribute that also tells you how rare the practice was, that it acquired a specific term. The legal complications of keeping one's name after marriage in the United States were not fully resolved until the 1970s, when several court decisions clarified that states could not require women to take their husbands' surnames and could not deny them the use of their birth names in official contexts. Hawaii was the last state to remove its statute requiring women to take their husband's surname upon marriage in 1976. Before that date, in Hawaii, the name change was not a social expectation. It was a legal requirement. What makes the name question particularly interesting as a closing point is what it reveals about the entire architecture of restriction we have been moving through tonight. The name is the most basic unit of individual identity, the word that refers to you specifically, that you have had since birth, that distinguishes you from everyone else in the room. The requirement that a woman surrender it at marriage, that she become Mrs. His name in documents and in the mouths of people who introduced her, was not merely a convention. It was a daily, public, repeated enactment of the principle that her individual identity was secondary to her marital one, that who she had been before was less significant than who she had become in relation to him. Every time someone addressed her by the new name, the old one was a little further away. The name was where the argument lived, compressed into 2 syllables, renewed every time someone said it. So here you are, still breathing, tucked in somewhere comfortable, in a bed that is yours, in a name that is yours, with a bank account that is also yours, and nobody, not a magistrate, not a husband, not a man with an iron cage and a chain, is going to do anything about any of it tonight. Think about what you just travelled through. Thousands of years of human ingenuity, applied with remarkable consistency to a single project. finding new ways to tell half the population to sit down, be quiet, and under no circumstances open a bank account without asking first. The Romans banned the wine, the medieval banned the laughter, the Victorians banned the trousers, the universities, and several colours of embroidery thread. The 20th century banned the marathon, the passport, and the ability to be pregnant and employed at the same time. Every era found its own version of the iron cage and called it protection, tradition, or the law of the creator, depending on which century it was and how much paperwork was involved. And through all of it, the women kept going. They ran the marathons anyway. They wore the trousers and dared someone to do something about it. They registered as KV, Switzer, and showed up with a bib number. They walked into medical schools that didn't want them and graduated first in their class. They wrote pamphlets they couldn't legally sign, brought cases they couldn't legally bring, and built institutions from scratch when the existing ones refused to open their doors. They laughed, loudly, openly, with their teeth showing, in rooms full of conduct manuals instructing them not to. They were not waiting to be permitted. They were moving through a world that had been arranged against them, and finding the gaps, the workarounds, the sympathetic judges and the unsympathetic ones worth fighting anyway. They kept meticulous records of every indignity and handed those records forward, so that the women who came after them would know exactly what had been done and exactly what it had cost to undo it. The restrictions we move through tonight were not footnotes. They were the architecture of daily life for women across most of human history, built into the law, into the buildings, into the paperwork, into the name you were called after you married. They shaped what was possible and what was thinkable, and dismantling them required generations of stubbornness from people who would not live to see the results. So tonight, as you drift towards sleep in whatever comfortable configuration you've arranged yourself in, maybe let that land for just a moment. The bed is yours. The name is yours. The passport in the drawer has only your signature on it. The laughter you laughed today, at whatever it was, with your mouth all the way open, belonged entirely to you, and nobody filed a complaint. That is not nothing. That is everything, earned slowly, kept carefully, and not yet finished. Sleep well,